If you don't like this bill, you can probably blame me and our firm because we actually won a case years ago against a homeowner who wanted multiple flagpoles. And the client said, no, you can have one flagpole mounted to your house in the front yard. The statute was a bit ambiguous, but ultimately we think it says what it says at ARS 33-1808. And it says, you can basically have one flagpole. Maybe a couple flags on that pole, but you get one. The association can allow more if it wants to, but it doesn't have to. Well, that was about 4 or 5 years ago. Fast forward to now, it appears that that homeowner went to the legislature, got somebody's ear, and next thing you know, now we have a change in the statute that now makes it absolutely clear you can have up to two flagpoles mounted from your side of your house. Now, does the association have to limit it to two? No, you can have 5, 10, 15, however many flagpoles you want to allow. But now you have to allow at least two usually in the front yard, but attached to the actual building, the structure. Now, Javier, this doesn't necessarily affect the typical flagpole in the front and backyard, right? This is wall-mounted flagpoles.
That is correct. So we have a little illustration here, and as Mark indicated, you can have up to two. I had a community where this came up with, so it's more of a thing than you think. And Mark, I think it's just because of the way maybe the legislature is just acknowledging the way that these wall-mounted bracket flagpoles are sold. I've never seen them with like two flags on one. Have you?
No, then this is legislature by anecdote because some homeowners don't like the current state of the law. The one that I had that we litigated, it was on each side of a door about 10 feet away from each other. There was a United States flag and say a Marines flag or maybe an Arizona flag, two separate flagpoles, two separate flags, and that's what they wanted. And they weren't able to get it then, but in about 4 months from now, congratulations, they will have this. So this isn't a huge deal. It cleans up the statute, makes it clear, but it just one more thing that we can't regulate as much as we could before.
All right. If you have questions about flags, reach out again in the chat or putting out there, and Mark and Nick will keep an eye. While you're thinking of those, I'm going to talk. This is actually going to apply only to condominiums. So if you're a planned community, close your eyes and your ears for now, but don't close them completely, because the trend that we've seen across the country and the trend that we're seeing in Arizona, at least for the last couple of years, is there is this push to either directly enhance owners' political rights in community associations. So this one actually deals with interior modification. We call it the owner hardwood flooring bill, but it's a little bit more than that. So what this bill says is if you own a condo and you want to put in things like hardwood floors or other things that might reasonably disturb your neighbors, that might have been prohibited by your governing documents, you have an express right to do so long as you quote, you install reasonably necessary improved materials, accessories, or other adjustments so as to minimize the potential disturbance. That's the first part of it. The second part of it, which I actually find a bit more interesting, is it says you can't prohibit any manner of decoration on the interior of the unit. And I've got a picture of a U.S. flag and the rainbow or the gay pride flag, LGBTQ plus flag as well. And this was actually out of the Tucson area. I think it might have been Oro Valley, probably about maybe 5 to 10 years ago. Somebody was really passionate about displaying flags from on their property. The HOA said, no, we don't allow all of these flags. And they said, fine, I'll use them as interior decorations. And so if you have a condo where, people are disgruntled and people get mad about all sorts of things, I think we're going to see people weaponizing this bill to put up, language and decorations like the HOA sucks or I hate my neighbor, who knows what. And who knows, maybe in 5 to 10 years, that'll be expanded into the non-condo planned community world. But for now, it only applies to condos. Key point here, if you have one of these condos where you have these types of prohibitions, talk to your management team, talk to an engineer, talk to your lawyers, and figure out what can you do to get ahead of the curve and figure out what kind of modifications, requirements you want to set forth in your guidelines. So give that some thought. And if you need some help with that, hey, we're always here to help. That brings us to our last major bill of the night, and then we have some other goodies for you. But this is the Corporate Transparency Act. If you've never heard of this, here's the background. You know that there are lots of nefarious operators throughout the world, people who buy and sell drugs, human smuggling, terrorism. They fund their operations through things like Bitcoin and other off the grid financial means. And so they're working to combat this. And as a result, they passed this bill that applies to basically any HOA, with very few exceptions. And there's an obligation to report some information that Mark's going to talk about. The deadline, is really coming up here, if not already in effect. And Mark, why don't you talk to us about who has to register and how this all works?
Yeah, so ultimately, again, it's the beneficial owners, which, conservatively is the entire board, right? But the only real good news here, other than it's a hassle, we shouldn't have to do this, we completely agree with you. But the only good news here, even though it's the entire board, is you don't have to provide that much to the government, and they already really have this information. So what do you actually have to fill out and give to the federal government? Well, your full legal name, which they probably already know, your date of birth, your current residential address, which the government knows they probably gave it to you, and then ultimately they'll spit out a unique identifying number that says, hey, here's what you need to give back to CINFEN to prove that you filled this out. And you just got to make sure that you're properly updating that when you have board members change in and change out. And you also got to make sure that when someone comes into the board that's new, say, hey, you got to fill this out. To serve on the board of directors of a nonprofit corporation, you're going to have to fill out this information. If you don't want to do that, maybe you should think twice before serving on the board, right, Javier?
Yeah, it's definitely a point, and you've got to submit this report. But there's also some requirements that once submitted, you do have to update it. So something we want you to all know is this is a pretty big deal. There've been some legal challenges to it as time progresses. Our thinking about it has kind of coalesced because there've been a couple of competing views. Does everybody on the board have to register? Is it just officers? Is it just the board president? At this point in time, I think that we're most comfortable saying that the most conservative approach is that everybody who's a director should sign up. To be fair, Nick, we're not aware of any CTA police who are monitoring this stuff, are we?
Not yet, but if history is any indicator, I'm sure somebody will be appointed eventually.
Yeah, probably, right? Here's just some screenshots of what it looks like to register. But there are civil and criminal penalties, right, Nick? If you don't.
There are, yes. And again, even if you read these, you can sort of appreciate what Javier was saying about the intent behind this. But for now, it still applies to HOA. So failing to report can result in a maximum penalty of up to $500 per day, up to $10,000 total, and even imprisonment for up to 2 years, which seems wild in the context of homeowners associations. But we're going off the plain language. And oh, perfect, Jeremy, good timing. What are the consequences of not complying with the CTAs? Well, there you go. Maximum penalty monetary of $500 per day, up to $10,000, and imprisonment up to 2 years. Now, as people on the call are most likely going to be concerned about, the penalties are not only going to apply to the community association that fails to report, they may also apply to an individual, particularly obviously the imprisonment one, which you can't really imprison a community association. So, when it comes to these penalties, it appears to be based on the language in the bill or in the law. They're going to be broadly applied to associations that fail to comply, and they'll be applied to any individuals, such as the board president who refuses to comply, or who causes a community association not to report. Or if we're correct on our interpretation and a senior officer of the community association fails to report or update, we believe that the penalties will probably apply to that individual as well. So definitely something to take serious, but as we've discussed here, not a terribly difficult one to comply with. This will be one that we will be monitoring developments. It's being challenged across the country with varying results. We will certainly be monitoring it, and we will keep certainly CADN updated along with all of our clients as well as decisions come out regarding the application of it.
All right. So if you have questions about that, reach out to the team and they'll.
Well, there's a couple more in the chat,
Yes.
Javier. So when do we need to start reporting? No later than the end of this year. And then after that, updates every 30 days if something changes on the board. Do the directors...
And Mark, just to put an emphasis on that, the change could be as simple as you move from like lot 1 to lot 15. That's going to actually require an update, because if your address changes, that's enough to trigger an update requirement.
Good point. So when in doubt, update your information, especially for new directors as well. Make sure they're updating it. So help a friend, help a neighbor out. Next up, from Carol, do the directors register on their own, or does the management company do it with Arizona Corporation Commission? Is there a fee? So I would say get with Jeff and get with CADN to see if they're going to help you out, and then we can probably assist as well, or assist CADN as necessary. And Javier, do you remember what the minimal fee is?
I don't recall off the top of my head. I'm sure we can look it up. We do have the website here. So it's a two-step process. You have to, first, get your information. Then you're going to be issued, a identifying number. And then you go ahead to the website and just fill in all this information here. So it's not onerous, but, it does take some time. And you definitely want to make sure that you do it. So if you have those questions, reach out to Jeff and his team, and if they need any help, they'll let us know. We'll provide some legal guidance.
Yeah, and then just to address the other questions here in the chat, we will be sending out communication to our boards of CADN's position and if we're able to assist in those reporting. So more to follow on our side as well.
Perfect.
Yeah. All right. Our last topic of the night is municipal law update. So I want to put some emphasis here before we get into it. There's two bills that have been signed by the governor. Now, neither of these directly applies to either condos or planned communities, but we're getting a lot of questions about them, and we thought it was just important to share some guidance on it, so that if it comes up at a meeting, you've got some good walking around knowledge. So Mark, take it away. Let's talk about some casitas, please.
So like Javier just said, these should not apply to you, anyone on the phone, all right? Unless you're working for the city or something, that's a whole different issue. Doesn't apply to HOAs. But Javier and I both had a call just this last week from managers saying, hey, how does this apply? Should we be worried about it? So you probably will get some questions on it. This is SB 2720. We call it the Casitas bill because it's about accessory dwelling units, so ADUs. It is, again, aimed only at municipalities. So cities, towns, counties, etc., not at HOAs. And it just says what cities have to do, what towns, what counties have to do, that basically they're going to have to allow these types of accessory dwelling units with certain type of exceptions, right? But what if the association has in their CC&Rs or design guidelines or anything like that that says we don't allow 2 homes on a lot, we don't allow accessory dwelling units, we don't allow casitas? You don't have to now. All right, just know the city. So if you're in the city of Tucson or the town of Oro Valley or Marana, you're going to listen to the city saying, sure, you can put that casita in your backyard, but they still might need HOA approval. And the HOA, as long as you've got language in your CC&Rs or design guidelines, you can still say no. Or you can still say, no, it can't be that big, or it can't be that tall, or it has to be painted a certain color. So this is just going to really affect cities, and you'll see some changes, but just know you can tell the homeowners we can still do our own thing based on our own governing documents.
Yeah, so if you for have property that's within the city of Tucson, you're probably aware that Tucson adopted some pretty extensive ADU modifications last year. I think last year when we talked to you around this time of year, we were talking about this stuff. So some of these provisions are going to actually preempt local town and city requirements like Tucson's. But again, if you've got questions, talk to the team. Our last topic for tonight is one of my favorite, backyard chickens. I don't know if any of you, any quick show of hands, anybody out there maintain backyard chickens? If you don't know what backyard chickens are, it's kind of an evolving hobby. It's gotten really popular in the last 25 years or so, where people are raising chickens in their backyards, hence the name backyard chickens. People do it because, apparently they're fun to have. I like plants myself, but to each their own. But I do love fresh eggs. Well, chicken people are very passionate around the country and locally. They've been working on this for about a dozen years, and finally this year they struck gold. What this law does is it trumps municipal and county prohibitions against an owner's ability to maintain backyard chickens on their property. You can have up to 6. And so one of my best friends, who's a big-time criminal defense attorney, called me and said, Javier, does this mean we can have backyard chickens? And I happen to know that he lives in an HOA. And I said, so-and-so, no, you got to check your documents, because a lot of CC&Rs say no chickens, or they only allow certain types of animals, or they say we've got rules. So what do you need to know? There's this law about backyard chickens, but just like with the ADUs, you have to check your governing documents. Key point here, a lot of governing documents don't have tight language about whether or not backyard chickens are a domesticated household pet. So we recommend reviewing your governing documents ahead of time, because it's always helpful to have rules that say, hey, we're going to permit it or we're not going to permit it. And if so, this is how we're going to do it. Why should you care about this? I'll tell you why. Because a lot of owners who have these chickens will allege that they're emotional support chickens. I've dealt with emotional support geeks cases. Hey, look, we take disabilities here very seriously. There are a lot of consequences for a fair housing claim. The law's changed on that. If you've got a situation like that, please let Jeff and his team know, and we can help you with that as well. But it's harder to make that argument now than it ever was before, but you still have to be tight on your governing documents. So keep all that information in mind. That completes our prepared materials for tonight. Our contact information is here. If you have a need, reach out to Jeff and the team, reach out to Nick, Mark, or myself. We do have some resources for you. In fact, this was just completed today. This is our new law guide. It's a one-pager. It summarized all of the changes in this year's law. And it's broken down according to the topic and references the bill as well. So it's kind of just some great walking around knowledge. If you're familiar with our firm, you know that we put together a statute book and some slickies. Those are still at the printer. We're hoping they're going to be out available near August or September. But if you'd like a copy, they're complimentary to everyone. Please either let Jeff and his team know, let us know, or you can just email info@chdblaw.com. My final announcement for tonight, and then I'll turn things over to Mark and Nick for 2 quick things. Because of these extensive changes with the collections bill, we're just letting all of our clients know that we are transitioning our collection programs effective June 15th. Because we're just want to make sure that everything's tight. And so if you're using us for collections, talk to us. We've got a new program. We'll have some marketing materials about that, a contract as well. But you can think of it as a deferred billing collection plan. It includes foreclosure. Got a lot of experience. It's pretty similar to what we've been doing with many respects. And with that being said, Mark, actually, Nick, you want to talk to us about the street parking regulation package? Because I think we're less than a year out now, pretty much, right?
Yes, I'm sure if you've ever attended one of our changes in the law presentations for the last couple of years, you're aware of the change to ARS 33-1818, which speaks specifically to any planned communities whose documents were CC&Rs recorded prior to January of 2015. And if your association regulates on-street public street parking. That might actually apply to some of the people in the room right now. What this change says is that if you live in one of those associations with those specific parameters, that the association must, by June 30th, 2025, hold a vote of the membership to determine whether or not the association wishes to continue to monitor or regulate the public streets. And I think there will be a lot of development. There will be a lot of interesting challenges to this, in the next year or so. But what we are offering for our clients, or prospective clients, I guess, is a flat fee to produce all the paperwork and the voting materials and the notices for associations to conduct this vote. It's going to be an interesting next year or so, particularly I think in about 12 months, it's going to get really interesting as associations scramble to put together the materials, make sure they comply with the law to get the vote done by June 30th, 2025. So we are offering just a tight package of it for $950 to our clients for all the materials for the vote. And then if the vote passes, we will actually record the resolution confirming the association's decision with regards to the vote for a flat fee of $250. So keep that in mind over the next year or so, as if you live with one of these associations and you're getting ready to put this vote on.
All right, thanks, Nick. And our final announcement tonight, our condo insurance notice.
And a quick additional plug for what Nick just talked about with the public street parking. We're having a lot of clients that are doing this at an upcoming annual meeting because it's easier to get quorum, right, at the annual meeting. So if you got an annual meeting coming up, now is the time. If you have to do this parking on roadways regulation vote as well, do it all at the same time. It's cheaper, it's faster, it's better chance we'll have it passed. If you are in a condo and not in a planned community, pay attention to what you've got to do now going forward for the condominium insurance. We also offer a flat fee package on this as well. It's $950 to make sure you comply with the statute. And ultimately, on an annual basis now, condominiums have to send out a notice to all of their owners telling them, one, the information on the owner's responsibility for their own insurance and the deductible for property and liability coverage. So what kind of insurance you need and how much it is and how much the deductible is and who pays the deductible, whether it's the owner or whether it's the association. So we've got to send that out annually. So if we can help you at least send out that first one and make it easy, and then you can copy and paste it going forward, feel free to do that. But make sure you're sending this out if you're a condominium association.
All right.